Anton was criminally charged with illegal possession of a firearm. The Firearms and Explosives Office issued an initial firearms holder verification report via email, indicating that Anton is not a licensed firearm holder. Based on this report, Judge Frazier issued a search warrant authorizing a search of Anton's residence. During the trial, Anton argued that the search warrant was invalid since the case records did not show that Judge Frazier had asked searching questions of the applicant and witnesses, a requirement to establish probable cause against him. In response, the prosecution maintained that the verification report from the Firearms and Explosives Office was sufficient to justify a finding of probable cause and the issuance of the search warrant. If you were the Justice of the Court of Appeals, how would you decide this case? Explain.
If I were the Justice of the Court of Appeals, I would decide in favor of Anton. The Constitution provides that no search warrant shall issue except upon probable cause to be determined personally by the judge, through examination under oath or affirmation of the complainant and the witnesses he or she may produce. The Supreme Court ruled that as a rule, the state may only conduct searches and seizures pursuant to a valid warrant, which requires that the judge must examine under oath or affirmation the complainant and the witnesses he or she may produce. Here, since there were no records shown that Judge Frazier had asked searching questions of the applicant and witnesses for the issuance of the search warrant, failed to comply with the requirement that the judge must examine under oath or affirmation the complainant and the witnesses he or she may produce. The initial firearms holder verification report alone is insufficient to sustain a finding of probable cause against Anton, as it only certifies that he is not licensed to possess any kind of firearm. But it does not in any way prove that Anton is in actual possession of any firearm. Thus, I will decide in favor of Anton.